Okay, we're gonna start. Today we're gonna discuss the standard essential patents in Europe, and we have three speakers. Each of participants introduce by himself. Please start, Andreas first.
Hi everybody, my name is Andreas Wietzke. I'm partner of Mathys Squire in the Munich office, and I'm leading the litigation team here in Munich as well as the telecommunication engineering and IT team. In the former firm I worked for, I also was responsible for some telecommunication litigation going on in Munich and Düsseldorf, where we represented Vodafone at that time against intellectual ventures. So I can talk also a little bit about or out of my personal knowledge of the topic we're talking today. Andy, please.
Hi everyone, I'm Andrew White. I'm a partner at Mathys Squire in our London office. I'm a UK and European patent attorney. Over to you, Ed.
My name is Edward Cronan. I'm a barrister based in the UK. I specialise in patent litigation and also FRAND licensing litigation. And I've worked for companies including Apple, HTC, and Vodafone.
So thank you for joining, everyone. This is just to overview what we're going to discuss today. We will discuss some of the recent SEP litigation that has been going on in Europe. We're going to discuss what this means for SEP holders as well as SEP users. We are going to try and understand that litigation is a tool that can be used as part of the FRAND license negotiations, and that it has been endorsed by the UK Supreme Court. And we're going to also identify some potential pinch points in the law where there may be divergences in future between practice in the UK and Germany.
What first prompted this webinar was the decision of the UK Supreme Court in a case called Unwired Planet and Huawei, which has now been continuing for over 5 years. And the Supreme Court's judgment is seen as one of the most important judgments in FRAND litigation and telecommunications anywhere in the world. The UK became the first country in the world in which any company which owns a standard essential patent is entitled to ask an implementing company to take a license, which is not just a license for the United Kingdom, but a license worldwide, a global FRAND license. The judgment will therefore have large effects on companies around the world, not just those that operate in the UK. It will affect companies who contribute to standardized technologies, as well as those that use standardized technologies such as 3G, 4G, AVC, video coding, connected cars. So any company operating in the UK using a standard technology will now be given a choice by the court of taking a global license to a patent owner's entire standard essential patent portfolio that is used by their product, or the product being removed from the UK market. The court, in offering this global license, will settle all the commercial terms, including a license rate for different standard essential patents in different technologies, and they will set the rate according to the strength of the patent portfolio based on evidence of what would have been concluded in a willing commercial negotiation. There may still be some occasions where the court will not set a global rate, and those are likely to be in situations where the technology is not portable, for example, DSL or cable internet access. Some companies have shown themselves to be uncomfortable with the UK allowing for a global license. Last year, a company called Zeisel, who I was representing at the time, left the UK market in order to avoid entering a global license. And there will remain strategic options for companies who want to minimize their license costs. However, leaving the UK market is unlikely to be an effective option. There is a general feeling that other countries will now follow suit and follow the UK in setting global license rates. So there is little to be gained by trying to leave the UK to avoid such a license. For most companies, the license set by the UK court will be on fair terms. It will be based on comparable commercial licenses and will respect the need of the implementing company to profit from the devices it sells. However, some companies may perceive there is a risk that the UK courts will arrive at the wrong license rates. Some companies believe the rate settled in the Unwired Planet and Huawei case was too high for products sold in China, for example, where the rate was 50% of the rate for Europe and the United States. Despite that, companies may find that they choose to stay in the UK and take a global license to minimize the costs of overseas litigation. Additionally, if a company leaves the UK in order to avoid a global license, they may still be liable for up to 6 years of damages for past use of the standard technology, and those damages may be on a global basis, but the Supreme Court has not yet confirmed.
Thanks, Sid. So one of the things the Supreme Court discussed was the non-discriminatory aspect of FRAND, with the UK Supreme Court decision distinguishing between so-called hard-edged non-discriminatory obligations and more general obligations, indicating that the obligation can vary based on the commercial considerations. The UK Supreme Court noted that fair, reasonable, and non-discriminatory should not be seen as 3 separate obligations, but rather as a unitary whole, whereby the third prong provides focus and narrows down the scope for argument about what might count as fair or reasonable for these purposes in a given context. One of the things the court did was look to Etsy's IPR policy, and so doing, they concluded that price discrimination is the norm as a matter of normal licensing practice and may promote objectives which the Etsy regime itself is intended to promote, such as innovation and consumer welfare, and therefore that it would have required far clearer language in the Etsy FRAND undertaking to indicate an intention to impose the more strict, hard-edged, non-discrimination obligation for which Huawei contended. The UK Supreme Court indicated that a so-called fire sale royalty rate can be acceptable and does not set a new or lower benchmark for future FRAND rates. What this means in practice is that a rate does not cease to be FRAND simply because the SEP holder had previously granted a license on more favourable terms. What the court effectively did was reject the notion of a most favourable license. What this meant in the present case was that Unwired Planet did not have to offer the same royalty rates to Huawei as they had given to Samsung in a 2016 license. One of the things the UK Supreme Court decision noted was that there was an obligation to treat like cases alike, because the same rate is made available to all licensees who are similarly situated in the sense that they seek the same kind of license. However, the UK decision does not discuss what similarly situated means. Could it be similarly situated, for example, in terms of size, as some commentators had previously suggested? Meaning, for example, that you could charge a different rate to a multinational to an SME or a small or medium-sized enterprise? No, this would be discriminatory, with the court indicating that it expects the same kind of rate for the same kind of license. What this does do, however, is raise the question as to whether different rates can be set depending on the field of use. For example, as we're seeing with the Internet of Things or applications in the automotive sector. And really, this is a key question, as we're going to see in future the connected home and the Internet of Things going to lead to vast divergences in the value of devices incorporating standardized communications. What we're seeing already, actually, is some patent pools already taking this into account, with them providing and publishing rates with some level of divergence, for example, with HEVC Advanced and Avanci. This is quite a big difference from what we've historically seen in the sector, for example, with smartphones. With smartphones, most handsets cost and were sold at roughly the same rate, so it made sense to talk about a percentage cost. With the Internet of Things and connected vehicles, the absolute costs vary drastically from your $2 million Bugatti to your smart plug, for example. There therefore tends to be a discussion of a price per unit cost rather than a percentage cost. This is generally what people are calling component level licensing, and is something my colleague Ed is going to just touch on briefly in a minute. There's also the question of whether the rate should vary depending on where in the supply chain the license is. And this is an interesting point that was raised in a recent Nokia and Daimler dispute in Germany, where Daimler were arguing that Continental, their tier 1 supplier, should be the ones to obtain the license, not the car maker, the OEM themselves. And again, I believe my colleague Ed and Andreas may touch on this briefly further on in this discussion.
So from a German perspective, we have two main issues to look into. The first one is that there is an agreement between the UK courts and the German courts that there is not one single friend rate to be applied, but there is the possibility to have different levels of license fees for different licensees to reflect the specific circumstances. So the German court system, based on a decision of the Federal Court of Justice, like the highest court in that case, decided that different rates can still be friend, fair and reasonable and non-discriminating if they are reflected by the circumstances. The big difference between the German court idea and the UK court idea is that in Germany, the courts up to now did not make up their own calculation what the royalty rate should look like. So while the UK courts try to fix and calculate a number by themselves and present it to the parties, the German courts did not do so yet. The strategy of the German courts seems to be to leave it to the parties to discuss the royalty rate, and thereby they suggest that the parties themselves know the best if something is friend or not. And to keep the pressure on the parties that the negotiation is going in the right direction and they're really following a path to find a compromise on the license fee, they use the pressure of the automatic injunction in Germany, which is still in place, which is an issue we will talk later a little bit more in detail. So at present, the German jurisdiction applies a relatively high level on how rapidly both parties are negotiating and how rapidly and how proactive they are communicating with each other. This leads to a situation where on the SEP user side, you have to be proactive to come to a friend-based offer to your SEP user as fast and as proactive as possible. If you don't do that, you would lose the potential automatic injunction and thereby the biggest weapon you have. On the other side, if you are an SEP user and if you don't communicate proactively to find a friend compromise on up to your perspective, you would increase the risk of getting an automatic injunction because you're not the willful potential licensee the CJEU as discussed in the Huawei versus SEPs litigation. So based on that, the difference in Germany at present is that there will be different friend rates possible, but the calculation is left to the parties. However, the pressure is put on the parties to really find rapidly such a friend rate.
One of the questions that Andrew touched on earlier, and which is not resolved in any jurisdiction, is the question of where in the supply chain licensing should occur. Now, in Unwired Planet and Huawei in the UK, and in fact in almost all of the litigation in the UK to date, the product has been a smartphone. And consensus in the industry points to the fact that licensing for standard essential patents is at the level of the phone, rather than at the level of the baseband processor or any of the components within the phone. This dispute becomes much more significant when we move from a smartphone, where the wireless communications technology is central to the device, into other forms of mobile technology used in, for example, connected cars. In Germany, we have so far seen quite conflicting thoughts on the issue. For example, in the Mannheim courts, there is the possibility that Nokia will obtain an injunction against Daimler covering the use of its wireless technologies in cars in the country. But in conflict with this, we have a ruling from the German Competition Authority looking to refer questions to the European Court of Justice about whether or not Nokia is obliged to license not Daimler, but Daimler's suppliers, tier one suppliers, as they're known in the automotive industry, who supply subcomponents of the cars to the manufacturers. The consequence of this can be very important because, as we've discussed earlier, a number of the license rates are set on a proportion of the sale value of the product. So for components within connected cars, these might be bought for prices in the hundreds of euros in comparison to the price of a complete car, which could be 100,000 or more. In the United States, there have been similar issues. And one of the long-standing aspects of United States damages law for patents is something called the smallest saleable patent practicing unit, which in various cases has been held to be either the computer processor or some chip within a smartphone or within a wireless router, rather than the device as a whole. The idea being that the court then calculates damages based on the component rather than on the whole device. In the United States, a first instance judgment by a very influential judge had decided that Qualcomm, the chip manufacturer, had engaged in anti-competitive practices by refusing to license its technologies to other chip manufacturers. In a very significant recent judgment, the United States Court of Appeals for the Ninth Circuit, one of the regional appeals courts in the United States, decided that this judgment was fundamentally wrong and that what Qualcomm did was entirely allowed. One of the reasons it gave for this was that in the mobile devices space, in mobile phones, it was standard market practice to license to phone manufacturers rather than to other chip makers. However, what the United States Court of Appeals did not address was whether or not SSO terms, i.e. FRAND terms, as we're discussing today, did mean that Qualcomm was obliged to make such offers. So in both Germany and in the United States, there are open questions about whether or not companies are obliged to license any company in the supply chain rather than just the end manufacturer. And I think we will expect similar disputes in the UK. And this is certainly an area where any company, whether as a licensor or potential licensee, has the possibility of saving or making a great deal of money on its licensing transactions if it can optimize the place in the supply chain where it takes its license.
So back to the UK Supreme Court decision now. One of the interesting points that came out of the decision was the notion of clawback clauses, or a way of effectively renegotiating the rate based on litigation that may occur in other territories, for example, where a patent may be held invalid or infringed. The UK Supreme Court decision expressly indicated that it might be fair and reasonable for an implementer to reserve the right to challenge a sample of the licensed patents in the relevant foreign court as a mechanism to lower the royalty rate. The UK Supreme Court explicitly noted that it is a sensible way of dealing with unavoidable certainty. What this means is that litigation is in effect expressly endorsed by the UK Supreme Court as a proper way to test patent validity and essentiality in FRAND license negotiations. However, careful thought would need to go into which patents are tested and in which territories to achieve whatever target royalty rates are desired. The decision also discusses how factors such as the importance of the market and whether it is a place of manufacture are likely to be important in considering whether such challenges are what they call at a cost proportionate to what is likely to be achieved in terms of eliminating relevant uncertainty. What this means in practice is that we can expect to see such clawback clauses in SEP licenses in future as a means of reducing relevant uncertainty at a proportionate cost. Litigation is now very much part of the negotiation process and has been endorsed by the UK Supreme Court. Furthermore, the strength of the SEP portfolio in key jurisdictions where the licensee has most sales or manufacturers may be an important factor in determining final royalty rates and may govern future litigation. Another important point that was raised by the UK Supreme Court was that it expressly commented on patent assertion entities, or PAEs. The decision noted that there is no legal base under the general law for treating such PAEs, or PAE owners of SEPs, any different from any other SEP owners. But then they went on to say, unless they have different interests which merit different remedies. The UK Supreme Court went on to say that it is not evident that a PAE should necessarily be treated differently from a SEP owner which manufactures and sells telecommunications equipment. While PAEs may likely be emboldened by this statement saying that they should not be treated any differently, it does state that PAEs may have different interests which merit different remedies, and that they should not necessarily be treated differently. It raises the question then whether there is scope for further law to be developed on this point. In the case of non-essential patents, PAEs may therefore not be entitled to an injunction, but only to damages in lieu of an injunction. However, the UK Supreme Court held that enforcement of a FRAN license was a legitimate reason to grant an injunction for a PAE.
We have already seen that a number of patent assertion entities owning standard essential patents have begun further activity in the UK as a result of the UK Supreme Court's decision. So while there will be increasing intensity in license negotiations for multinational companies in the area, in the knowledge that the UK will now set these rates, there are also already companies who have decided that those negotiations will be assisted by coming to the UK court. In particular, Conversant has brought additional lawsuits against both Apple and LG in the last week. There is also continuing litigation between Optus and Apple, Optus being the parent company within the Unwired Planet group, so now owning the Unwired Planet portfolio, which was the subject of the UK Supreme Court's decision. So we'll see further FRAND licenses settled by the UK court within the next year, in particular in relation to 3G and 4G telecoms.
So we've briefly mentioned injunctions and whether they're an equitable remedy. And this was one of the key questions that the UK Supreme Court answered. Importantly, they held that injunctions are an equitable remedy and that damages in lieu are not an adequate substitute. The UK Supreme Court held that injunctions are necessary in balancing the interests of SEP holders and implementers. As discussed in the decision itself, the possibility for a national court to grant an injunction is a necessary component of this balance, as it ensures that implementers have a strong motivation to negotiate and accept FRAND terms for the use of the SEP portfolio. The UK Supreme Court went on to note that if the patent holder were confined to a monetary remedy, implementers who are infringing the patents would have an incentive to continue infringing until patent by patent and country by country they were compelled to pay royalties. However, this does raise an interesting question that may need to be addressed in future, particularly, for example, in the automotive sector or in safety critical sectors, about what might be equitable if the relevant technology itself is safety critical. This is likely to be the case, for example, in connected autonomous vehicles. Would an injunction be an equitable remedy then?
So the UK court has recently given judgment in several cases where they decided that a full injunction would not be appropriate, and certain acts and time periods were carved out of the injunction in order to allow the party to keep selling the invention on the market for reasons of public interest. These decisions were based on the Intellectual Property Enforcement Directive, which is in force in the EU, which requires that relief for intellectual property infringement is proportionate. The cases so far have related to medical devices, principally replacement heart valves, but the principles are of wide application. The issue is one of public health or public safety, and we could see this come to light in cases where wireless technology or standard technology becomes deeply integrated in products that we use every day. So whether this is wireless pacemakers, medical devices that alert people as to sort of falls at home for the elderly, or for connected cars, safety features such as essentially anti-theft or collision avoidance, which may use video sensing technologies or wireless communications, for example, to report an accident. And there will be arguments about whether these kind of functions can properly be turned off in response to a patent injunction, or whether or not they could be carved out, or whether the injunction could be limited in order to allow these important safety features to be maintained.
Also in Germany, the injunctions are one of the key issues in patent litigation. So in the present legal situation, there's the Article 139 of the German patent law, which grants what we call an automatic injunction. That means that if the court sees and rules positively on the infringement, and the patent owner asks for the injunction, the court immediately grants the injunction. So there are certain circumstances where the court, based on case law, is already now able to think if this is reasonable or if disadvantages to the society or the infringer would apply if an injunction is granted. But basically, the present legal situation provides the automatic injunction. To ensure that it's not enforced in a bad manner, and in particular, if it's that it's not enforced if a ruling is not legally binding yet, the courts in Germany have the possibility to set a so-called security bond. We have seen this in the latest decisions of the Mannheim court in Nokia versus Daimler, as well as the Munich court a few weeks ago, also against Daimler in the Sharp case. In particular, the Mannheim case was interesting because this was an injunction, an automatic injunction granted by a first instance ruling. However, the security bond was set to more than 7 billion euro to enforce it if the appeal is still running, which Daimler said they will do. However, this opens up a very sharp weapon against Daimler in this case, and this is a very good example how such automatic injunctions have influence on an economical situation and thereby have strong influence on negotiations between the parties. If you can consider that Nokia as well as Sharp are both parties of the Avanci pool, it may make sense for them to enforce by paying 7 billion euros the automatic injunction out of the first instance. And that would lead to the situation where Daimler has to withdraw about 50% of its cars from all of its resellers, which is an immediate and massive damage and a negative effect for Daimler, and thereby increasing pressure to negotiate to find an amicable solution. So, as you can imagine, the automotive industry is very much aware that the threat of automatic injunction threatens their business down to the core. The arguments of the automotive industry is that it's a difference if you have just a mobile network, which you switch off due to an automatic injunction, and your remaining customers may have a slower connection, or if you're an automotive car company, you are losing customers by having to stop selling your cars. Every day you stop selling cars, the customers would buy another car, and you would have lost them for the next 5, 10, or even more years. This is why there's a lobbyism going on in Germany right now to put pressure on the government to change the law. At present, the legal department of the German government is working on an amended version of the patent law. The first draft they provided earlier this year has provided an amended wording of Article 139. And it included that the enforcement of an injunction could be excluded if it's disproportionate due to the circumstances. The legal response of the patent community in Germany was, in general, that this is just put in phrases, in wording, what is common knowledge and what is based on the case law from the last 10 years or so. About 3 weeks ago, at the 1st of September, the legal department of the German government issued a second draft of amendment of this article, which is slightly different. It now says the claim shall be excluded, and it's meant the claim for automatic injunction, if its fulfillment would lead to disproportionate disadvantages for the infringer, and then, very importantly, or for third parties. So, once again, it's generally based on the case law, which is active up to now, but new in the law, according to this second draft, is that it would also apply to third parties. And this, in my personal opinion, is directed to the question which still remains open all over Europe. What is the European idea of having the freedom who to grant a license to? are there third parties to be taken into account if you get an injunction? Which means, is there a pressure on a patent holder to grant a license also to a supplier, a tier 1 supplier for automotive, for example? And if they don't do this, would they maybe lose their automatic injunction? So this is just a hint from the German government, which is in line with the latest ruling of the highest court decision in Germany, as well as the statements of Mr. Cronan from the higher regional court in Düsseldorf a few weeks ago. There may be more to come. There may hopefully be some referrals going on a European level, so we may gather some more clarity on that. But up to now, we don't know that. However, it seems that the willingness to amend Article 139 of the patent law exists on a political basis in Germany, but it will not go as far as the automotive industry wants. And according to the German Patent Society, this is a good thing, because to have a patent and to have a strong patent, you need a strong weapon if you enforce it. And if the automatic injunction is weakened significantly, then you would lose the strength of the weapon, and the equality of arms would not be existent for negotiations in the future. So up to now, we don't know for certain. However, we know that there will be a development in the legal system in Germany within the next maybe 1 or 2 years.
So one of the aspects that we were most keen to discuss was what are the practical steps that SEP users, standard essential patent users, can take in order to minimize their risk. Because there are obviously a lot of patent holders who will be looking to improve their licensing income as a result of an environment in Europe that looks increasingly favorable to them. The important thing is that there are a lot of positives for patent users in the current environment. Most important is that the UK court in particular has set out a process which can be very fair and which can be very transparent in order to allow the licensing of standard essential patents. First of all, for SEP users, there is a lot more information available now about the total amount they're likely to have to pay. For example, in 3G, the total royalty rate is likely to be around 5% and around 9% for 4G standard essential patents. With that kind of baseline cost in place, and that is of course for mobile handsets, with that kind of baseline cost in place, it's possible for standard essential patent users to reach out to patent pools and to patent owners who declared to standard setting organizations and find out what are the FRAND rates that are on offer. And what the UK Supreme Court has said is that those patent holders must offer their price list. There can't be a back and forth while the SEP owner tries to find out what the user can afford. There must be an offer put forward of a standard price list. This allows a patent user to build up a very accurate picture of how much they will have to pay in order to operate. And this can allow for accurate budgeting of license fees and a conclusion of a sort of freedom to operate package, which will allow them to use the standardized technologies they need without fear of additional litigation costs or disputes arising about the need for additional licensing.
This is more or less identically true for Germany, and I think this is what was the outcome of our discussion yesterday, that by facing the general risk of potential patent infringement when entering a foreign market, the rulings in the UK and in Germany now offer a risk reduction. So it's on the one side possible to increase certainty on the number of patents which have to be used, and it increases certainty on the number of euros to be spent on royalty rates. And this can both be done upfront before entering a market, and thereby can be used in the budget for the product. So coming from uncertain risk of patent infringement, we increased now the certainty if a client is now willing and prepared in detail to discuss the potential risk and the risk reduction awarded by the latest litigation.
So we are approaching now the end of our webinar presentation. And just to provide an overview of some of the key messages from today's webinars that we've heard. First is that SEP licenses will be global, and that a global license will almost certainly be FRAND. We've also heard how FRAND rates can vary based on both commercial circumstances and potentially the field of use. We've also heard that the UK Supreme Court has expressly indicated that injunctions are an equitable remedy. However, as we've heard from my colleague Andreas, the law might be changing slightly in Germany, and we'll watch this space to see what happens. We've also heard how patent assertion entities may be emboldened by the UK Supreme Court decision that expressly indicated that they should not be treated any differently to other SEP holders.
Thank you, three of you. Okay, we are running out of time, so we gotta end the finish. So thank you for the speakers, and also thank you the audience for the attending or taking the time to attend. So we gotta end. Thank you.
Thanks very much.